So today we are going to see about the list of deliverables in a construction arbitration. So construction arbitration is not like general commercial arbitrations or other issues. They have a specific set of deliverables that has to be submitted during every construction arbitration. So construction arbitration life cycle has a phase from initiation, pleading, evidence hearing, awards, and post-awards. So what are the pre-arbitration or notice stage deliverables? So it contains the notice of arbitrations or invocation of arbitration during the pre-arbitration stage. Next is the tribunal constitution deliverables. So usually in institutional arbitrations, there should be terms of reference. In ad hoc, they follow the act or jurisdiction which what says about the arbitrations. Then procedural order number 1, procedural timetable that has to be followed by both the claimant as well as the respondent during the entire arbitrations like submissions, pleadings, evidentiary submissions, everything. And what is the agreed list of issues? If preparedly, this has a very preliminary set of issues that will be discussed in the initial preliminary meetings. So pleading stage deliverables. So these are very important deliverables. So these are the deliverables from the claimant side: the statement of claim, detailed statement of the case, particulars of the claim, quantum calculations, interest computation sheet, and list of documents that contains or the annexes that are being annexed with the statement of claim. So what are the pleading stage deliverables from the respondent? Of course, statement of defense and counterclaims from the respondent on if they are setting off any claims, and defense to the counterclaim. This is usually from the claimant, if applicable. Of course, certain arbitrations they agree for rejoinders also to submit. Documentary evidence delivery. See, construction arbitration is completely a evidence-driven trial. It's not an argument-based trial like in litigation. So arbitration is the most procedural and binding award-giving ADR among all kind of ADRs. So these are the very important documents. It starts from the contract agreement, general terms and conditions, particular terms and conditions, bill of quantities, approved baseline schedule, updated schedule, as-built schedule if available, and delay analysis and EOD claim that was submitted during the time of project execution from the client, site instructions, variations, site diaries, minutes of meetings, correspondence, which are, there might be huge number of correspondence, not all correspondence like letters and emails has to be submitted. But what are very relevant to this claim has to be submitted. Daily progress reports, cost data, progress reports, everything has to be submitted. It might be submitted in hard copies or in electronic data as per the agreed discussion between the tribunal and the parties. Technical and expert deliveries. The construction arbitration is a kind where the necessity of experts is huge, because not necessarily the arbitrators shall be from the construction background or technical background. They take the help of experts who can break down the issues and help them in finding the correct justice for the party which has been damaged. So it usually includes delay analysis report, like time impact analysis or window analysis. Mostly it is forensic kind of delay analysis because parties go to arbitration at the end of the project. So retrospective delay analysis such as built, as planned will be used. Quantum expert report, who has to quantify the damages that has been made in the delay. engineering expert reports, for example, if there are any design allegations, change in scope allegations, or design defects by the employer being a claimant. So in that cases, they engage engineering experts, forensic planning reports, productive analysis in terms of disruption claims, acceleration assessment. Rebuttal expert reports are nothing but countering a claimant's expert report by the respondent or countering the respondent's expert report by the claimant. So joint expert statement, which is an outcome of hot tubbings, where both the experts are being able to cross-examine themselves and they are asked to settle down to the issues which they agree and which they don't agree. Next is the witness deliverables. So it is a witness statement. The first is the fact witness statement. Fact witness statement is party-owned witnesses that the claimant will have their fact witness and respondent will have their fact witness who actually worked in the projects. Then comes the expert witness. Even though an expert appears on behalf of claimant, they are independent and they don't give any biased report for the claimants because they're being paid by the claimant. Similarly goes to the respondent. Apart from this, the tribunal themselves can appoint an expert, irrespective or other than the claimant's expert or the respondent's expert to understand the situation more further. So rebuttal witness statements, as we discussed, that the countering statements, witness list, cross-examination notes, hearing bundles. So coming to the hearing stage deliverables. First is the opening submission, which will be a short PowerPoint to make them understand, or it might be a written letter. What are the closing submissions? The skeleton of the arguments, authorized bundles, case laws, transcripts of the entire arguments. Nowadays, they use AI to transcribe the entire arguments, daily hearing notes, cost submissions, post-hearing deliverables after the hearing is completed. So the closing submissions will be on the written format, and reply for the closing submissions also will be in the written format. The statement of costs and interest computations updates as on date for the award, and clarification submissions if tribunal requests. So what are the deliverables by the tribunal itself? So we all know it is award, not just the award. The first is the procedural order, interim awards if any, partial awards if any, final award, the cost award, corrections or interpretations if requested from the parties. Post-award stage. So award has been completed. And what are the post-award stage deliverables? Like application for corrections under the Arbitration Act or rule, enforcement of the petition. If required, it is required. It is required for the enforcement and challenge the petition. That is, for example, under Supreme Court of India, if the party that has not won the arbitration can challenge it under certain grounds, such as patent illegality, etc. And what is the statement agreement if post-award settlement happens? For example, the settlement agreement is signed between both the parties, then they agree on the award so that there will be no challenging against them, so they can directly go for the enforcements. So special construction specific deliverables. Because you work extensively in delay and claim space, these are extremely important, especially for the audience who usually see my videos. So approved baseline, critical path identification, EOT analysis, prolongation cost calculations, head office cost calculations, Hudson, Emden, and nicely. Even though if you go for a hypothetical calculation, these are just only reference benches. You have to submit the actual cost that has been spent by the contractor or the employer on this. Disruption analysis, measured mile study, acceleration cost assessment, concurrent delay assessment. So 70% of the battle is document control in arbitration. Only 20% is expert credibility, and plus 10% is advocacy or arguments. by this, we come to the end of this video. Thanks for watching. And if you want to know any other topics that will help you in excelling or empowering your entire team of construction, let us know. And if you want any support in claim submissions, arbitrations, please contact our team details below. Thank you. Take care. Bye.